Welcome back to You Belong in the Room, a podcast from Powership, where we have conversations that help women participate more fully in the decisions that shape their lives, from career and relationships to health and legacy. This podcast is for educational and entertainment purposes only. It is not intended as a substitute for financial, legal, or tax advice. Consult a qualified professional for your specific circumstances. And today, I'm very excited to be with Natasha Girouard. We are going to talk about a topic that most people love to avoid until life forces them into it, and that is estate planning. Now, we're going to talk about wills and trusts, family decision-making, and conversations that tend to make people feel very uncomfortable because they relate to death, which is one of the taboo topics, in addition to money. And so we often think that there's a reason we rationalize why we could save it for later. This episode is about clarity. Avoiding this conversation actually makes for worse consequences later. So I am so excited to see you, Natasha. Natasha works closely with individuals and families. She helps families navigate estate planning, incapacity planning, trusts, family structures, and long-term decision-making. What I appreciate about Natasha, among lots of things, is both her ability to address the technical side of these questions, which is quite specialized, with ease and aptitude, and not ignore the fact that these conversations are extremely emotional and take really empathetic listening and understanding the clients she's working with. So from this perspective of care and values and helping people feel more comfortable, I want to get into both of the substantive and technical side while addressing the fact that we cannot extricate that from the very real emotions that this topic brings up. So let's jump right in, Natasha. Please, first of all, welcome.
Thank you so much. It's such a pleasure to be here.
I'm so happy to see you.
I feel blessed to be here and to share the experience and to share with women what I encounter in my day-to-day, thanks to you.
And I think before we even get into it, one of the really special things about you, Natasha, is I think you're in touch with yourself. And I think in order to do your job well, it is key that you yourself are comfortable having vulnerable conversations. So
That's true.
I think that's an important piece of this whole conversation, and being able to do well in having the conversations for oneself.
That's true.
And finding someone they can work with who they can talk to.
Yeah. I think the listening part is also very important.
Yeah, definitely. So start us off, please, high level. Give us an idea. What is estate planning and why do we avoid it so much?
Estate planning is an expression that is being widely used, and it could mean a lot of things, but basically I see it as four items.
Mm-hmm.
We all know what a will is.
Mm-hmm.
We'll talk about it a bit later.
Yeah.
Then there's the protection mandate.
Yeah.
This is something that is not that common, and it should be as common as a will. When you draft a will, you should think about also your incapacity. So a protection mandate is to protect someone that is vulnerable.
Mm-hmm. Because it is also less and less common to go from black or white, alive to dead, without any period of incapacity.
Exactly. And it's the incapacity of someone is very difficult because we don't know for how long that person is going to be requiring health, medical care, etc. So it's very, very, it puts a lot of pressure on the family.
Mm-hmm, mm-hmm.
The other thing that is included in the estate planning, is all the global analysis of our own situation. If I want to do my estate plan, I need to figure out who I want to protect, for how long, why, who I want to make a gift to, which could be charity, a friend, which would have nothing to do with protection. and I need to understand my assets.
Yeah.
So, do I have life insurance?
Mm-hmm.
Do I have debts?
Mm-hmm.
If I have a company, is it part of my estate or not? And you would be surprised how many people don't really understand that concept easily.
That's actually really interesting because I don't think I ever fully crystallized this idea before that the reason we could avoid it is in part because we don't want to think about the potential eventuality of things going a certain way, which they necessarily will for everyone.
Looking at our balance sheet make us realize that if I'm gone tomorrow, there's not enough for my family. Maybe it's a realization that, and then you don't want to think about it because it's just scary.
Yeah.
It's fear.
Yeah.
Right? So there are solutions like life insurance, etc.
Yeah.
But you still need to face the reality. Why are we lacking in comfort talking about estate planning now that we know what estate plan is? I think it comes from fear.
Yeah. It also, I just jumping in.
Yes.
Whenever I teach lecture on money, financial literacy, investing, I always talk about the emotional aspect and weight that money holds. And this relates directly to exactly what you're talking about. You have to face your financial situation in order to even get to think about what you want to do with it.
You need to understand it.
Yeah.
I think there is a deep thing about if I accept to think about estate planning then it means I accept that I am not immortal.
Yeah.
We have responsibilities.
Yeah.
We have projects we're working on. We have families. We're raising kids. We have spouses. We have friends that are counting on us.
Yeah.
And it cannot be an option in our mind.
Yeah.
So we don't want to think about it. Sometimes I think people are not comfortable talking about or thinking about their own passing because we don't know what's going on after.
Yeah.
Not comfortable talking about incapacity because we're used to be in charge of our family, we make decisions. Women, when they start thinking about estate planning, they want a perfect document to sign at the end with a ribbon and, perfect. The problem is a will is a document that represents your life. And your life is not static. Your life evolves every day.
Yeah.
You meet new people. You discover that someone you thought was nice finally is not nice.
Yeah.
Your life is changing constantly.
Yeah.
So your will is going to be perfect just for one day, I think. So if we start with that, maybe we can simplify the whole process that our will not cover. Well, now I'm 55, I have a son who's 16. Well, I cannot cover when he's going to be independent and when he's going to be out of university and when he's going to have children. In my will, I don't talk about my future grandchildren. It's too far away, it would be too complex. I will never sign the document.
Yeah.
Because too many things can happen.
I've had that exact experience trying to support a client working through this process and them us going back and forth and thinking about the what ifs and the different ages of the kids. Exactly. And if it's going to happen in a decade or 2 or 3, things will be drastically different.
Completely different.
And in the end, that was the solution. The solution is, we'll change it.
Yeah.
Just get something on paper that makes sense today.
What if you pass tomorrow?
Yeah.
I think that's a good question.
Yes.
And can we stick with that plan? Well, we can stick with that plan for how many years?
Yeah.
Usually 5 years is good.
Mm-hmm.
But if something happens within 3 years, then we need to adjust.
Mm-hmm. With every big life event.
Yeah.
Mm-hmm.
And just start small with small decisions with what matters the most to you.
Mm-hmm.
What matters the most to me is my son, obviously. So who's going to be the tutor if I'm gone?
Yeah.
That's what matters to me the most. I've signed 9 times my will because of things like that since he was born, because I want to make sure that document reflects the reality. It's just I'm aware of that life-changing process, right? And the impact of not having a will that is up to date.
Yeah. Yeah. And it's interesting because there's avoiding addressing it. And then there's avoiding treating it like this living document as you're describing, right? And having an outdated situation.
Exactly. You know, if you bequeath something to someone and you pass in 20 years and you haven't been speaking with that person for 15 years,
lucky
he's
them.
like a stranger. Well, that person's going to inherit. Your liquidator cannot make a change. It's too late. Right? So,
plus your values, right? Like we've discussed this a lot, but your values could change.
Yes.
Like actual circumstances can change and you could evolve as well.
Yes.
So
totally.
It's a really good exercise. I think the flip side of the avoidance and the emotional nature of addressing the topics and the issues is that it's a tool. Right? Like I always love to see it as an opportunity, a tool to figure out what you have and what does your balance sheet look like? What is a balance sheet? What does it look like? Right? And then also, who are you? What's important to you today, now?
And I can add on that, you know, when you prepare those documents, protection mandate and will, you choose people that will represent you because you cannot administer your assets anymore, or so your liquidators or your mandataries, those people, when you draft your documents, you know them, but they also have the right to evolve. So not only you evolve and you need to review your documents, but you need to make sure that the person you designated 10 years ago, they still are the same person with the same values, right? So it's like a Rubik Cube. There's many faces to it, or where you need to make sure you have the right people in place. And it's not going to be perfect.
No, it never is, right? So let's get into a bit more of the concrete topics. Like tell us, what is a will? So I know we know, but just in case we don't totally know.
So a will is a document that is unilateral. So we're talking about estate planning in Quebec. The law is different in our province than the other provinces. So it only applies here. The civil code provides that we cannot make a joint will here in Quebec, with one exception, and I'll explain that later. So you write a document and you sign it, and it's in that document where you make sure you take care of other people, where you protect other people by designating a tutor for a minor child, by creating a trust to send assets to upon your passing for the benefit of a generation or many generations. You identify who's going to manage those assets. You can also specify what you prefer for your funerals. And there are many types of wills. And a lot of people, families ask me, the format of a will, is it really important? Well, the answer is yes. There is so much jurisprudence on wills. So there are 3 types of wills. The handwritten one. So you take a piece of paper, you write your will, this is my will, you sign, you put a date, and as long as it's handwritten by you, it's a valid document. So if in a couple, someone writes both wills by hand and the other sign, it's not valid. Okay, it's very important that it's your own handwriting. Because
makes sense.
So that's the first type. Second type is a will drafted signed in front of 2 witnesses. So you can write it by hand if you want. Anyone could write it by hand, almost. and you date it and you sign it in front of two witnesses. So what you need to share with the witnesses is that this is your will, but you don't need to share the content.
Oh.
And the witnesses, they cannot be mentioned in there. So if I bequeath to you my house, you cannot be a witness because the bequest to a witness is void.
Yeah.
Okay?
Makes sense.
Yeah. And the third type of will is the will that is signed in front of a notary.
Yeah.
So it's not only the signature, it's you go see a legal person that is giving you information, the legal steps to think about, the tax sides of it, and then they prepare the document, and then you sign in front of the notary. So what is the difference?
Yeah. Tell us.
Well, one, it's number one or two. So handwritten.
One is easier at first and harder later, and
well,
harder at
that's
first,
it. Yeah.
easy
So
later.
if you write it on a piece of paper or you sign in front of two witnesses, well, that document can be lost.
Yeah.
Nobody's in charge of keeping it forever, right? That document can be have wrong interpretations. If there is no legal person that helped you going through the process, maybe you forgot something important.
Yeah.
And those documents need to be verified by court.
Yeah. Which?
So in Montreal, it's a 4 months delay.
Yeah.
Plus maybe $10,000 of fees.
Yeah.
That could have been avoided if you had a will that is
because maybe you were saving money at the beginning.
Yeah. So if it's a notarized will in Quebec, it means it's an authentical document.
Yeah.
It's very difficult to contest.
Yeah.
We make sure that the person in front of us is the person that she or he pretends to be.
Yeah.
With identification documents.
Yeah.
So that document doesn't need to go in front of a court. What you need to do is a will search.
Yeah.
So in any case, any type of documents, you need to do a will search. You need to have the death certificate from the État civil.
Yeah.
And then you need to do a search at la Chambre des notaires and le Barreau du Québec because lawyers are also able to draft wills.
Yeah.
And us notaries, we have to file a form twice a month for all our career to la Chambre des notaires to put a list of all the person that signed a will and a protection mandate in front of us.
Oh.
So anyone could do a will search when someone has passed.
Right, which is also how you know
which one is the last one.
Yeah. What happens if someone doesn't have a protection mandate or doesn't even have a will?
That's an excellent question. So the rules are different from one to the other. So if you don't have a will, where to start? Well, the law is deciding for you.
Yeah, there's a default legal
in Quebec,
regime.
There is a default regime.
Yeah.
And it works with it's a table.
I remember it.
Okay?
I remember it from the bar.
From the bar, yeah. So it's a table. And it only looks at the factual situation of your life.
Yeah.
So for example, if I'm married with 3 children and I die without a will, it's 1/3 to the spouse, 2/3 to the children.
Yeah.
1 child, 3, 5, it's 2/3.
Yeah.
If I'm not married and it's just a common law spouse and we're not married, we've been together for 40 years, we have children together, the spouse receives nothing. There's a new law in Quebec that has been in force since June 2025, where common law spouse that give birth to children or adopt children after June 2025, they are now covered by this rule.
Yeah.
So they would receive, the spouse in my example would receive 1/3.
Yeah.
I don't know if I'm being clear.
Yeah, you're totally being clear. I picture it almost like a tree, you know, like you could like...
exactly.
But the thing is, and I think the point is that if you are deciding to not make a decision, that is a decision.
Yeah.
Right?
So
like
let's give you an example where it wouldn't make sense.
Yeah.
So I have a husband.
Yeah.
When we met, he had a 2-year-old daughter. And So I raised that daughter. We've been together for 20 years.
Yeah.
We had children.
Yeah.
So we have 2 children together, and I've raised with him that daughter that I love,
Yeah.
right? And I die without a will.
Yeah.
We're married. He gets 1/3.
Yeah.
And our 2 common children only,
Yeah.
they get 2/3.
Yeah.
And the daughter, she doesn't get anything. So it doesn't factor in those possibilities. It's very tricky.
And it obviously doesn't factor in any specific needs.
No, exactly. And it's just, you look first, if you have a spouse, no descendant, no father, no sister, brothers, then the spouse gets 100%.
Yeah.
And then you just follow that tableau.
Yeah.
And so that's what happens if you don't have a will, and it takes more time because there are extra steps to go through. And if you don't have any mandates, then the civil code provides for something also. It's a tutorship. It's private. C'est la tutelle au majeur.
Yeah.
So it's complex. It's heavy.
Yeah.
The notary is keeping the document forever in a vault.
Wow.
So you're going to find the document, anytime.
What are some of the biggest misunderstandings that people hold about?
It's a great question. So I signed my will with my spouse, with a notary. We sign it together. We each have a will. Well, the next day, my spouse could see another notary and sign another will. Nobody's going to know.
Yeah.
Nobody's going to call me, the spouse, or the notary that received the first set of documents. We're only going to know when he passed. I could sign my will in front of a notary and then write a will on a piece of paper. And it's the new, more recent document that is valid.
Yeah.
Even if the form is less strong.
That's interesting.
So it's the latest one.
Wow. So people must get surprises.
All the time. It's very hurtful when you thought that the estate of a loved one would say something and it doesn't say that. So that's why we encourage people that sign will to share with their families what's in there and why. Share their own values, their core values, share with them. And sometimes we do a reading of a will at our office while everybody is alive. And then we explain why.
Yeah.
And you don't need to talk about numbers, but just to
understand
what
intention.
are you expecting from your adult children to do with their estate? Are you expecting them to pass it on to their own children, right? And maybe not to their own spouse. But you understand that when you have children yourself, right?
Yeah.
So we do that, and it's very helpful because it's better to know.
Okay, so I have a tough question, or I think it is, and maybe the answer is it just depends, but is it better, or do you recommend that people in a relationship, let's say married primarily, work on it together? Do they come see you together? Or is it better to come on your own?
It depends.
Yeah.
So let's say you have a husband for the past, 30 years, and you have children together, and it's your first marriage. Well, if you know everything from each other.
Yeah.
But what if the situation is different? And what if, unfortunately, you are separated from the parent of your children and you have another spouse? Well, maybe that other spouse, even if you live together, maybe you're not comfortable that that other spouse knows everything.
Mm-hmm.
But when you don't talk about finances,
then
it creates fear. It changes the comportement.
The behavior.
The behavior.
Yeah.
So what we see often in blended families is we see a conflict of values. So if I'm drafting my will and I have children from a previous union and I have an actual spouse, and maybe I have children with that spouse too,
Yeah.
maybe just to add complexity.
Yeah.
Well, what's my goal? So that's the first question. What's the goal?
Mm.
Well, usually the goal is to maintain the lifestyle of the spouse for a while or a lifetime,
Yeah.
while protecting the capital that I have accumulated for the children from the first union and from the second union.
Yeah.
So people don't know how to do that.
Yeah.
But we developed, obviously, planning for that because more and more
It's common.
families
Yeah.
it's more common to have blended families.
Yeah.
So maybe the second spouse doesn't need to know all the assets underlying in the estate, but maybe it would be nice for that spouse to understand that her lifestyle is protected.
Yeah. That she's being taken care of.
Yes.
Yeah.
So c'est du cas par cas.
Yeah. Yeah.
It's a very good question.
And so while we're talking about wills, I think we should ensure, or at least explain to me, how you address will with a bridge to protection mandate.
Yeah.
And is similar thinking and values applied to both documents?
Well,
Or let's take a step back. What is a protection mandate?
yeah. What's a protection mandate? Well, another step back, what is incapacity?
Yes.
Okay, so a protection mandate is there to protect someone that is vulnerable.
Yeah.
Well, that's the first step. So in Quebec, to be incapacitated, you need to be declared by a court. To have a judge make that decision, you need assessments.
Yeah.
From a doctor and from a
Social worker. Yeah.
So it's a long process and it's very complex. If my parents are elderly and my father is starting to lose memory
Which is a lot more common.
This is, a lot more common, and I understand the doctors and the social workers are very reluctant to
take away someone's capacity.
Yeah.
Yeah.
But then they need protection. So there's another conflict of core values here. So it's important for my parents to still be able to go to the bank and pay their bills and all that. But at the same time, maybe they don't know anymore about the value of money. And maybe they're going to make wrong choices, and maybe someone's going to be...
take advantage of
them.
Yeah.
So that's why we need to manage
Yeah.
when the incapacity kicks in.
Yeah.
It's very difficult to draw a line.
Yeah.
And it depends on the families, because I read a statistic where when someone is being financially not harassed, but
abused.
Yeah. Usually it's
their own
by
family
members.
Yeah.
Okay. So when someone is in a bad financial situation and is pumping money from someone that is vulnerable, well, I think it would be a good point to start doing the process of the homologation of the
protection
mandate. But
I think it is very hard. I just want to make sure
I didn't really answer the question. So you're incapacitated when you cannot make decisions for yourself, or you cannot manage your property because of a sickness or an illness, or because you were in an accident.
Yeah, a condition.
A condition. So you could be born with incapacity.
Yeah.
It could be partial, or it could be total. So it's always different from one person to the other.
And there's an appreciation.
Yeah, from another human being.
Right, from another human being.
So,
and things could be good one day and less good another day.
And the families are making their own
assessment.
The spouse usually covers for the lose of memory and all that.
Yeah.
And everybody is making their own
determination almost.
Yeah, but
Like,
the word I'm looking for is deuil.
oh,
It's
grief.
not the same
It's
speed.
mourning.
Yeah, because
Yeah.
when someone is losing, when a loved one is losing capacity,
Yes.
the people around that
Yes.
person is going through many, many, many changes and accepting that their parents are losing their capacity is very difficult. Everybody doesn't mourn at the same speed.
Yeah.
So it's not everyone that is ready to do that step of the assessments.
Yeah.
Even if there's no challenge with money. It's just a human.
Yeah.
You're losing your parent petit à petit. It's very difficult.
And you're accepting that the reality that you were used to and the person who you knew is no longer.
Yeah, and imagine that person,
same.
how that person feels.
Yeah.
Now that your children need to take care of you and make decisions for you.
Yeah.
It's very challenging.
Yeah. And there is a real tension for every well-meaning person between wanting to preserve the independence and, let's say, previous reality that this person experienced that you had with them, and having the ability to protect them because that is clearly factually no longer the situation.
Exactly.
And I think determining, like you say, knowing when, like, you're more than 50% or you know, like you're erring more on the side of needing to protect them.
It's very difficult.
It's very difficult.
Yeah.
It's very difficult.
So what does this protection mandate, what's the content of that document? Well, it looks like a will.
Yeah.
You identify the person that will take care of you. So you could have a committee of people that will make decisions for your health.
Yeah.
And you could have another committee of people that will make decisions for your assets.
Yeah.
And you could have subcommittees. You could have someone that's going to make decisions for your business, or a committee for your business, for the cottage. You could have other people. Because when you're drafting your protection mandate, you're thinking about after incapacity, it might be my passing. So what you put in your will as bequests, well, that will's not going to be available when you're incapacitated. So if you want to protect the cottage for one child, you need to say something in your protection mandate.
Interesting.
Not to sell it. Maybe, it's important to me that I still have that cottage to be able to give it or bequeath it upon my passing.
Yeah.
So if nobody's using it, maybe you can rent it.
Yeah.
You can say that in your protection mandate.
What are some other things that are surprising that need to go in the protection mandate?
Yes. Well, you need to think about who you're supporting economically right now. So if, as a couple, we made a decision that my spouse is going to be a stay-at-home spouse, and so if I become incapacitated, it's very important that that spouse maintain a lifestyle, right?
Yeah.
So we need to say so. We need to say if I have separated from the parent, the father of my son, I need to say that we need to consult with the economical agreement we have together concerning the fees or the expenses for my son, right? Because I want to continue assuming the expenses for my son because it's important for me. Let's say I bought a condo for my mother. So I bought a condo, it's under my name, but my mother is living there.
Yeah.
And she's not paying a rent.
Yeah.
Well, if I want this to continue upon my incapacity, I need to say so. Because she's taking an advantage from my assets, right? And my mandataries, they don't know for how long I'm going to be incapacitated. So their role is to grab all the assets they can and make sure they make it profitable because they don't know for how long I'm going to be sick and they don't know how much it's going to cost. And in that document, that's where you say or you specify your wishes about end of life. So if you prefer not to have heroic therapeutic measures, heroic diagnosis measures, that's where you put it down.
Yeah.
You need to share that information with your family, but at least black on white on paper.
Yeah.
Whereas if you drafted a protection mandate, you can choose different people with their own interest and their own skills
Yeah.
and their own values. So I think it's much more preferable
Yeah.
to draft a document. And on top of that, if you don't have a protection mandate, the person that will manage your assets will have the simple administration. So they will not be able to sell any assets, and they will have to invest your assets in sound investments.
Yeah.
And that's very limited because
Yeah.
it's to protect a person that is vulnerable again.
Yeah.
So it makes sense that that person is not going to invest in a new company that, is very risky.
Yeah. Or
But
even
at the
growth
same time,
stocks.
if you don't have growth and you don't have
Yeah.
interest, maybe
Yeah.
you can talk about it.
Yes. Yeah.
Yeah.
No, it's very limiting.
It's very limiting.
It's very limiting. And just to make the entire link, let's spend a few minutes talking about powers of attorney.
A power of attorney
Yeah.
is a document that you sign today while you are fully capacitated.
Yep.
So it means you're over 18
Yeah.
and you're not incapacitated. And I can say, okay, Lindsay, from now on, you have access to my bank account or my investment account.
Yeah.
I prefer to have two people that are taking care so they can talk together, and it's more difficult to postpone decisions when, there are two.
And they would have to make unanimous.
Yes, unanimous decisions.
Yeah.
Usually a power of attorney is used when I cannot move to the bank. Maybe I was in a car accident and I'm in the hospital for 3 months, right? And I ask my children to take care of my things, but they call me and they ask me what I want them to do.
They just sign.
It is just sign.
Yeah.
It is limited, the power of attorney.
Yeah.
For example, if I signed a power of attorney and I'm 70 years old, I send a power of attorney and to my son, and I'm going into a home for elderly, and my son wants to sign the sale of the house in front of a notary.
Yeah.
Well, the notary has the right to be uncomfortable with the power of attorney because the power of attorney stops when the person that gave it is passed or is incapacitated. And as we understand, the line between capacity and incapacity is very thin.
Yeah.
So the notary usually, they want to meet the person that is the responsible for the sale.
Interesting.
So the power of attorney has certain utility.
Yeah.
But I totally understand why a notary wouldn't be comfortable signing a sale of a house based on a protection mandate, not a protection mandate,
Power of attorney.
A power of attorney, even if it's been notarized, because if it was notarized 2 years ago, a lot of things could have happened.
I feel like
then.
I have to ask you, have you ever been in a situation where you have encountered someone taking advantage of
We see jurisprudence every day.
Yeah.
Yeah.
So, yeah.
So it's a document that is usually useful for banking.
Yeah.
And the banks, financial institutions, they have a form
Yeah.
for that. Sometimes it allows only one person to be designated on the power of attorney.
Yeah.
Which to me is a bit uncomfortable.
So I have a question for you.
Yes.
What do you say when a woman says, my husband asked me to sign a power of attorney just because it makes things so much easier? Like maybe I'm not available during the day when he's meeting with the banker or the whoever, professional, and so he wants to be able to sign on my behalf.
It's a loaded question.
Yes. Yeah. Yes. What do
Well, first things first.
Yeah.
I think the power, to have power, is to have the knowledge. So
I love that.
if you don't understand what you're signing, I don't think you should be signing it first. If you don't know what it's going to be used for, I don't think you should sign it.
Yeah.
I don't want to get into couples there
No,
and into fights.
That's a different episode.
And I'm not the expert on that one.
Yeah.
That's why I think it's so important that when you meet with the notary for a will, a protection mandate, a power of attorney, everybody needs to be present to understand the. Remember we talked about the sandbox?
Yeah.
So I see this like a sandbox, and I see that I'm in a sandbox with limitations, and I want to understand what toys I'm playing with.
Yeah.
And when we start for the first time with drafting a will, we start with a small sandbox with a little bit of toys and a little bit of friends and family in the sandbox, and let's keep it easy. And then we can increase and enlarge the sandbox with more complexity as people are growing and the situation is, you're controlling what you've decided on the first document, and then you just grow up and up and up. So how can we be comfortable signing a power of attorney if someone else is deciding for us?
Right.
That's where I'm not comfortable. Knowing what it's going to be used for, to me, is very important.
Okay. So because we're touching on marriage, before we move on to kids, because I do want to get into, there's a whole bunch of stuff there, but what can you tell us a bit about the interaction? Because I think people might not realize the extent to which family law, and you touched on this indirectly before, but the extent to which there is a link and real consequences based on what's happening from a family law perspective and how that impacts your eventual estate plan.
Yes.
And we've often heard from a family lawyer.
Yes.
Right? Everybody gets divorced, whether it's during their life or upon death.
Yeah.
Right? So that's helpful in already introducing, but like it's very important. Corporate law too. There are connections between.
Totally.
Yeah.
Totally. So, I think, well, first of all, the matrimonial laws and family laws, again, it's a safety net that the law is providing you.
Yes.
Right? So if you marry in Quebec and you don't see a notary, you're married under a regime that is available for everyone with clear rules.
Yeah.
And basically it's 50-50, accept what you had before or what you inherit.
Yeah.
Those rules are stronger than your will. So the first thing that we're going to look at when we open an estate and we look at a will is we need to see if there's a marriage contract. If there's no marriage contract, were they married? If they were married, what date? And so what's the matrimonial regime? And then we need to calculate the assets that are covered by the matrimonial regime and make the split. And then whatever is left is going to be treated by the will of the person that passed.
Yeah.
So it's very complex.
Yeah.
Because of that, what we're doing as estate planners is that we have that discussion when we meet with couples and we say, so what's your matrimonial regime? You want to prepare your will. You need to understand that the law provides that you have those assets and you have those assets. So if you pass, well, you need to write a check to make it equal. That's the first debt. So we need to construct or make a construction of the will around this. Yeah. Because if we just forget about it, then when someone passes, we need to make that calculation and we're going to have surprises.
Which I don't know if I made it 100% clear before, but I think that there are major risks. Like as I'm listening to you and having been at step meetings where you are leading the conversation and there are experts and specialists all around the room asking questions, I think it's very important to say clearly that the way that a will is drafted, right? Like you said, there's the first two kinds, but if you're doing it with a professional, which I think we would recommend that
definitely
people do, is that even a professional could not think of all the potential consequences of,
I
like,
think
it's very specialized.
it is very specialized.
Yeah.
And I find the more I settled estates with liquidators, the more I'm knowledgeable of where it could
Go wrong.
sideways.
Yeah.
And the matrimonial aspects is one of them that is
a big
very,
one.
very important.
Yeah.
Because if you don't treat it,
Yeah.
what could happen is, for example, in a blended family,
Yeah.
if I'm married with a second spouse
Yeah.
and I have children from the first union, and it's the same example, I want to maintain the lifestyle of my spouse and I want to preserve capital for my children.
Yeah.
But if I'm married with that spouse probably has rights, right? And if I just ignore that and I say, okay, in my will, I want to make sure that you receive a certain amount of money, let's say 25% of my estate.
Yeah.
Let's say I bequeath 25% of my estate to my spouse, 75% to my kids. But then that spouse has a right in the matrimonial regime first.
Yeah.
So we call that a double. It's like that person receives the value of half of the family patrimony, plus she receives or he receives the RSPs because I bequeathed the RSPs.
Yeah.
So the end result is I thought I was giving 25% and I thought I was being fair.
Yeah.
But finally, you're giving more because you ignored the law that had priority, and your children don't receive what you thought they were going to be receiving, and maybe they really need it.
And I mean, I love that point, because even in circumstances where you could have the best intentions, things can be overlooked, and
completely
results can really...
We see that all the time.
Yeah, and that's a perfect segue into the classic conversation about fair versus equal.
Yes.
And children. And I really want to talk about children, maturity, ages, money, but also this really important idea about the difference between fair and equal. And how do you help clients navigate that?
Well, first I need to understand the situation.
Yes.
The first recommendation I would make is you need to be super transparent, even if it hurts, with your professional, so the professional can really understand what's going on and can factor in all those things. Like, tell me everything, and whatever I don't need, I'm just going to forget.
Natasha, I have to interrupt you to say this idea comes up very often through this podcast. It is so important to work with people you're comfortable talking to. Every professional in your life.
It's a basic.
Yeah. You need to build a team that allows you to be vulnerable and honest and transparent, because that is the way you will achieve the best results.
I don't know any other way to do this.
Yeah. Yeah. So sorry to interrupt you.
No, but it's true.
Yeah.
And if you don't do this, if you don't share with me that you don't really have any more assets. It happened. And you're drafting a will that is very complex, and it costs a lot of money, and it's because you want a will with trust. Then when you pass, you thought you were protecting someone, but there's not enough money because of the technicality. When you say, I give $200,000 to this person, this person, this person, this becomes a debt of the estate.
Yeah.
And you thought you were protecting the heirs with the residue.
Yeah.
But if the residue is empty because you paid your taxes and you paid the particular legacies, well, the person that needed protection, maybe that person's going to get nothing.
Yeah.
And this is terrible.
Yeah.
And
I've heard stories.
How can I know?
Yeah.
It's impossible for me to know.
Yeah. And how sad is it for the spouse or the children who, upon reading of the will or uncovering, find out that they actually thought they were in one situation and they're in a completely different situation.
It is an excellent point.
Yeah. So in conversations I've had, I find people still tend to divide equally. Are you finding that that's the case? And I mean, there's
Well, it's
equal division, and then what do you give, right?
Yeah,
you could.
but there's two things I think we need to look at.
Yeah.
There's the sharing upon the passing. That's a short-sighted version, I think, because I'm an adult, I have children, and during my whole life, I have acted maybe differently, not equally with all my children.
Yeah.
For different types of reasons.
Yeah.
For health reasons.
Yeah.
Because I have one child that is, doing a compétition équestre.
Yeah.
Horseback
Equestrian. Yeah.
riding.
Horseback. Yeah.
It's not the same cost as, competing.
Soccer.
Soccer, for example.
Yeah.
Yeah. So maybe someone is looking at the overall situation of their lifetime, including that in the will.
Yeah. Or one kid's in the business.
That's
I feel
very
like
difficult to understand when you're the kid that was doing the horseback riding.
Yeah. Yeah.
If I knew, that's what I hear doing estate settlement. And that's why I hear, well, if I knew, maybe I wouldn't have done that.
Wow.
Well, I understand when you're 16 years old, you don't have that discussion, but I think it's our responsibility as adults when we draft our wills to explain what we're doing and what's our perspective. And I've been doing this for 26 years, and I've never seen two wills that are identical.
Yeah.
And I get surprised every day by the thinking of the families that I'm meeting.
Huh.
It's every day. It's new. Every day we add on to our precedent.
Yeah.
Because every day I'm like, oh my God, I didn't think about that. That's such a great idea. Let's say I have two children.
Yeah.
One child, my daughter has 4 children, and my son has 0 children. When I pass, am I going to give 50-50? That's equal between the roots of my daughter and my son. It's equal mathematically. But my son doesn't have the same responsibilities.
Yeah.
But is it my responsibility as grandparents, technically, to take charge of those 4 grandchildren? Well, it's easy to talk about it when they're not yours. Okay?
Yeah.
So what I've noticed is following families over decades, you see that their vision is growing and changing. So when they have 2 children and they don't have grandchildren, then it's equal and it's easy.
Yeah.
Maybe some adjustments because one is in the business or this is another facet.
Yeah.
But then when the daughter has kids and kids and kids and kids, then it changes everything.
Yeah.
And then the heart takes over the rational of all the equality. And I'm not comfortable if it's not equal. And one way to fight that uncomfort is to create a section in the will just for the grandchildren.
Right.
So my example was a bit not harsh, but 0 grandkids, 4 grandkids. But if it's one that my son has 1 and my daughter has 5, maybe we can set a pool aside, a lot aside for all the grandchildren, and maybe 20% of my estate could go there, and then it's 40-40 for my son and my daughter.
Yeah.
So I get back to my equal thing. It's another layer of complexity.
Yeah.
And you don't start with that for your first will, but it's just a way to, and there's no right or wrong answer.
I have to ask, how often do you ever suggest to people to start giving or dealing with these more complex situations during their life? I always say, personally, that I don't think we should associate death with a windfall.
Death with what?
A windfall, right? Like the expectation of receiving a lot of wealth upon the death of someone is, there's a real perverse.
But you don't want to create trust fund babies.
And you don't want to create trust fund babies, right? So Which
Maybe
also,
you can explain what trust fund babies are.
well, I want to ask, so let's discuss, what is the right way to pass money on to children? Do you think of ages? Is it fixed amounts, percentages?
Well, it depends.
Yeah.
So sometimes families start transferring money when there is liquidity availability
Yes.
to their children while they are alive.
Mm-hmm.
And sometimes it's a test, which is okay too.
Yeah.
And sometimes it just makes sense.
Yeah.
We have a lot of families that come to change their wills because they had to help the youngest of their adult children to buy a house because lately it's been very difficult.
Yeah.
So what are you doing? If you help one and the other ones don't need the help, you prefer to keep? No, if I'm giving $500,000 to someone and one of my kids, maybe I have 2 other children, maybe I'm not ready to give away another $1 million. Maybe I prefer to keep it and make interest, but then I need to make a balance in my will.
Yeah.
So we see a lot of that.
Uh-huh.
Sometimes, and it was just an example with an amount, but it's sometimes families are able to make the balance right away.
Yeah.
And sometimes they're not.
Yeah.
We need to think about those children. Are they married?
Yeah.
If they divorce, is it going to go through the divorce?
Yeah.
So we know from the previous podcast that what you inherit should not be shared in a divorce, unless you use it in to buy assets that are shareable, and you lose the nature of it. So. And taxes are also very important. So if you transfer assets to a minor, then it generates taxes and it's no good.
Yeah.
If you transfer assets to your spouse to generate income, there's a tax retribution of the income to you.
Yeah. So there's a whole layer. That's like
so this is a bit, that adds a layer of complexity.
Yeah.
Now, in your will, when you want to split or pay or the trenches, and it depends. When you have small children, you usually it goes by age because it steps in the development of the young adults. Yeah. But at one point, the ages are not important. Mm-hmm. So if my sister is 47 and I'm 55, it doesn't have to be with an age anymore, but it could be, okay, we want the dust to settle. Yeah. So after our passing, let's wait 3 years, 4 years before we start giving the capital and maybe doing 3 trenches every 3 years.
That's really interesting.
So we do that a lot.
Yeah. It's because when the kids are young, to your point, like the consequences of giving someone a large amount of money at
they're going to make
20,
wrong
25,
decisions.
30,
maybe not wrong decisions, but different decisions.
Different, yeah.
Maybe I wouldn't have studied in like high math or something like that if I had, when I was at Cégep if I didn't have to. Yeah. Maybe.
Yeah, because the question often becomes like, how do you maintain the tension between raising kids and having them work hard and make the most of what they can accomplish?
Yeah. And that brings us to another subject. When a grandparent wants to give to the grandchildren.
Yeah.
How do they do that?
Yeah.
And how it can affect the relationship with the parent with their own children. Mm. So it's a generation skipping gift. So I want my grandchildren to remember me. I want to give them money. But then it has an impact on the relationship with their parent. Yeah. Maybe not for long because the money's going to be gone quickly, maybe. But, you need to think about this. Mm-hmm. So... and if you didn't say anything to anyone and just then so it's that a surprise
literally
to everyone.
Is what I was just about to say, is that communication and transparency.
Yeah. So communication with your professional.
Yeah.
And communication with your family.
Yeah.
And sometimes
some reckoning with yourself even.
Oh yeah, yeah. But sometimes you don't know what's going on with your kid. Yeah. You don't know that your kid has an issue with I don't know, alcohol or drugs,
Gambling.
and maybe
Yeah.
the issue is not the alcohol. Maybe the issue is underlying mental health.
Yeah.
And how can you know that? You know, if I have two children and they get along, they're gonna help each other, and it's gonna be fine.
Yeah. Because you said you have to face the reality, I think that that's also, in addition to communication, a very important point, because something you see very often is like, I want to leave my cottage, my country house for my kids to share because I envision, right? Can you just talk about
Such a good example.
Talk about a like secondary residence, country house, cottage situation for like.
This is the worst nightmare. First of all, I think we need to ask our children, do you really care about the cottage?
Yeah.
That's the first point.
Yeah.
Because it's a huge responsibility.
Yeah.
It takes a lot of time.
Yeah.
And if I'm retired and I'm taking care of my cottage and looking at the plants that are growing, it's beautiful and it's fine and I love it, and it's the point de rencontre for all the family, and it's my important asset to me.
Yeah.
Our children, maybe they have their own cottage.
Yeah.
Maybe they have children at a very low age, very
Yeah.
young children.
Yeah.
Maybe they don't have the time to drive up north or in the Eastern Township and take care of the twag.
Yeah.
You know, and it costs a lot of money.
Yeah.
So I think the communication is the key.
Yeah.
And if everybody is willing to step into that together cottage after the passing of the parents, there is some trust that we create.
Yes.
In a will.
Yes.
But we put money in there.
Yeah. Throughout all of these episodes and all these conversations, at the end of the day, knowing, like you said, it's the information, the knowledge that is the power. And that relates to in our relationships, communication between us.
Yeah.
Yeah.
And not thinking about it and not talking about it is not going to change the fact that we're not immortal.
Yeah.
And it's not going to change the fact that we could have a ski accident and become incapacitated.
Yeah. Yeah.
So I think to protect your loved ones,
yeah,
it's something that, you know, we need to start somewhere with something very simple.
Well, so I feel like we're just reading each other's minds, because the next thing I wanted to say was, what if someone says, well, I don't have enough?
Well,
you know, like what should we leave people with in terms of, you're going to start somewhere, do this
when
tomorrow?
Should you do it? When should you think about drafting a will? Well, you need to be over 18 first, okay? And then, do you have people you care about? Then draft a will.
Yeah.
Do you have a bit of assets assigned?
Yeah.
Draft a will.
Yeah.
I don't know. You have a competition bike. It's important to you. It could be important to someone. It could make a change in someone's life, right? For someone who's into sports.
Oh my God. I love this point so much, because I read and then wrote an article about this notion of sacred goods. And I just want to tie that into what you're saying, because this conversation and what you're doing when you think about your legacy and leaving stuff to people you care about, it doesn't only have to be high value. Like, this isn't a conversation only about money.
It has nothing to do with money.
Right.
It's accessory.
Right.
We need to think about it when we talk about the trenches and...
Yeah, money's very relevant.
It's important, but le cœur, the heart of that discussion is not that. The biggest fights we see in estate settlement are issues from the disappointments.
Yeah.
How come?
Yeah.
How come my father thought of giving watches to my brothers and not to me? Like, because they're men's watch. That's what the father thought. But the daughter is profoundly sad.
Yeah.
So it's
exactly that topic. The original article I read was from Step. And I was really fascinated, but it makes so much sense
Totally.
that the cause of estate litigation and the reason sometimes it could last so long and cost so much is because people are feeling like the things that are actually most important to them, feeling seen and understood, and the memories they shared are not being honored in the way they expected.
Yeah, I agree.
So,
Feeling seen is very, very important.
yeah. So it doesn't take much for you to be able to create a positive impact by thinking through what you have and who you love and what you would want them to have or to remember.
Yeah, and how do you want them to feel for the
Yes.
rest of their life about you?
Yes.
How you thought about them.
Yeah. Is there anything that we haven't covered? Because before we wrap up, no.
I think it was a good conversation.
So do
Very,
I.
very interesting.
So do I. Yeah. Okay. Yeah.
Oh, wait.
Okay. So now that we know when we need to start writing our first will or thinking about these conversations, these issues, how often, I mean, we talked about that it's a living document, that as life changes, we would think about revising. Is there a rule of thumb that you tend to give people?
Yeah, usually we think about 5, we do a follow-up after 5 years.
Yeah.
And then we finally meet at the 6th year
Yeah.
and we sign at the 7th,
Yeah.
you know? So we say 5, but technically it's 7, 8th year.
Yeah.
If nothing special happened.
Yeah.
But there's always so many changes. And
Yeah.
it's always surprising because, oh, I'm not that close to that person anymore. Oh, I'm not sure that person, that person's taking care of her sick mother. It's not a good decision to, it wouldn't be a good idea to ask her to be the liquidator in our estate.
Yeah.
And she wouldn't be able to say no. So, so every time we do a review, there's always something that you haven't thought about.
Is finding a liquidator, like what are some of the hardest issues? Finding a liquidator.
Liquidator and trustees, it's the worst.
Yeah.
So the trustees is the trust for a testamentary trust you're drafting in your will.
Yeah.
And
so either for a spouse or children.
Yeah. So it takes some qualities.
Yeah.
I think you need to be able to understand that you will need to work with professionals to do the estate settlement because laws and taxes are so complex that now it's...
Yeah, settling an estate is not for the faint of heart.
No, it's not. And you need to realize that if your 2 children are not speaking anymore, well, to designate them both as liquidators...
Together, yeah.
It's not a good idea.
Yeah.
Because, this is a story in your mind, in your head, that they're going to be, happy living together after you're gone. If they don't speak to each other, they will not. It's going to be very difficult.
Right.
So you need to face the reality and look at the reality. If you think that someone is not good with managing money, well, I don't think you should designate that person as a liquidator.
Yeah, it's a hard...
a job of liquidator is a hard job.
Yeah.
It's very difficult, more difficult than trustee. A trustee is just for a long period of time.
Yeah.
So what else could be important? You don't need to have someone from the family. You don't need to have a professional as a liquidator.
Yeah.
You just need to have people you trust.
Yeah.
People you trust, and assemble a committee that they will complete each other.
And I find no matter what, even if it works at first, as families grow, it necessarily gets more complicated.
Yes, absolutely.
So it is important that communication around desires, intentions, and realities.
And when you ask your children, would you like to have the cottage and use it while I'm gone?
Yeah.
You need to tell them, I don't want you to give me the answer I want to hear.
Yes.
I need to do the proper planning. We need to be clear.
Yeah. Yeah.
Yeah.
Yeah. This is so amazing, Natasha. Thank you so much. I always love exchanging. I learned so much from you. And I know that anyone listening will have picked up at least a few tips. Hopefully they're They've written some notes and they have some
Yeah.
to-dos.
But let's start simple. That's the key point, I think, to remember.
Yes.
Just let's do the first step.
Yes.
And
we started
start
there.
the process.
It doesn't have to be perfect.
Exactly.
Right?
It's perfect just for one day.
Exactly.
Right?
So start somewhere. Protecting people you love and making sure that your values are actually reflected in the structures around your life. Because like we often say, the decisions are going to get made. So make a difference, have your voice be reflected in the decisions that do get made about your life. Avoiding them, although we all have a very strong tendency to pretend things aren't happening, avoiding them doesn't make them disappear. So participate, come in the room, you belong there, and let's make the most together. Thank you so much for listening to You Belong in the Room, a podcast from Powership. If you enjoyed what you heard today, resonated, please feel free to share it with someone you know would appreciate it. I know that's my favorite thing to do with podcasts, when I love them. And if you want more information about the Powership Symposium, check out the website, powershipcollective.com. Feel free to also check out Powership Collective on Instagram for all the newest content and upcoming information about new episodes. Thank you so much for joining us.